this morning with case 24-0108. And it's, I want to make sure I'm saying this right. Is it Labadie?
Yes, Carol.
Okay. The Labadie versus Orlando Health et al. And Miss Carol.
Yeah.
And then at council table, we have. Well. Okay, Mr. DeLuca. Okay. With that, Ms. Carroll, you're recognized on behalf of the lab.
All right, thank you, Your Honor. Good morning. I'm Jennifer Carroll here on behalf of the plaintiffs in this case, Norma and Jude Labadie. I would like to reserve at least 7 minutes for rebuttal. If I can.
7 minutes?
Yeah.
Okay.
Thank you.
And then you can go ahead and change this real quick.
Okay.
Okay.
All right. Thank you, Your Honor. As we all know, every medical malpractice, medical negligence case is a battle of the expert. In this case, the plaintiffs, Norma Labadie and her husband, lost this battle well before the case even went to the jury. The jury had expert testimony connecting the dots, deviation of nursing standard of care, but the lack of it from the defense side. They didn't have that connection from the plaintiff's side. Plaintiffs were denied their right to present their theory of the case to the jury as a result of the exclusion of Nurse Attard's critical testimony regarding the defendant's deviation from the applicable standard of care. What's, I think, critical in this case, and that's why I want to lead with this, is the defense had their expert, their nursing expert, Tracy Key, give all sorts of testimony. She said she reviewed all the depots, all the records, and she was allowed to give testimony to the jury that nurses, hospital, never negligent. And nurse and Vasquez met all the requirements of pre-admission testing. And she specifically told the jury that all the symptoms that Mrs. Labadie presented when she went in on that day, August 9th, and other days, she had no obligation, Nurse Vasquez had no obligation to call Dr. Fell.
Counsel, or at least it was trial counsel, did they raise a timely objection to that testimony?
Oh, as far as Nurse Keith's testimony, no, I'm not aware of that, Your Honor. I'd have to, I guess, check the record again, but they were in a position where their expert testimony, their nurse expert testimony was going to be excluded on these specific issues. And that's what's critical here, is that the defense was allowed to go forward and give all this testimony by their expert, their nursing expert.
But counsel, wouldn't they say that testimony was properly disclosed and your testimony was not properly disclosed?
It was properly disclosed. The framework in this case, and let me just, put it in context here. First of all, you have, was Binger even applicable here? Because was there a deviation from the discovery depot, et cetera? And then, and of course, our position is really that it was not, okay? And if you say it is a new opinion, you still have to follow Binger in the analysis, and that was not done. And if we're talking about Binger, you can still have, even if it's a new opinion or a variation, the trial judge was required to analyze, was the prejudice to the opposite side, and this trial judge did not do that here.
Well, counsel, can we talk about that? I want to skip over your first issue, which I think is deserving of treatment, and this is if it's actually undisclosed.
Right.
But if we get to the Binger analysis, we're
Yeah.
sitting with the trial judge who's reviewing a deposition that was taken before, taking Binger objection after Binger objection after Binger objection. The one that we come to here on Nurse Attard's opinion, she did not go, you are right, through all steps of her analysis. But where in Binger does it say she has to make findings on the record each time she makes a Binger ruling? It just tells her what analysis she needs to follow. Am I incorrect in that?
Well,
Does she need to state on the record how she goes as to each of the factors in Binger?
she has to analyze it, and it's either going to be on the record or that's how you're gonna tell, it's either on the record or in writing.
Well, let's
But
go back to the record, right?
yes,
She took a Binger objection as to chest pain immediately before she took this Binger objection, correct?
yes,
On the chest pain analysis, she does go factor by factor in the Binger analysis, correct?
that's right,
Which tells me she knows it,
right.
okay? So what's the evidence that she didn't apply it when she came to your,
Well, there was another discussion, of course, with regarding, it was separately done, right, as to each excerpt of opinion testimony, right? And she did it on the chest pain, that's right. But on the others, on the specific testimony that we laid out in the brief, and I can quote it again, but
Yeah.
specifically, yeah, the presence of pain would cause any nurse in a pre-admission testing to do some fetal monitoring, to call Dr. Feld to see if he's willing to perform an NST, what's an NST? And then continues, after Nurse Vasquez performed the respiratory therapy, did Nurse Vasquez report this at the chain of command? No. Does the applicable standard of care require Nurse Vasquez to report the respiratory therapy up the chain of command? Yes, all that was excluded. And then with the diagnosis of preeclampsia also, which that was included, Nurse Keith was allowed to go into that issue as well. So the judge did not address the issue of prejudice to
On
the other
the-
side with respect to this particular excluded testimony.
she didn't do it on the record.
Right.
We don't know if she did it in her head.
Well, I think that's all we can really go by is what, I
Well,
don't think we can speculate what she was saying in her head.
The question that was asked, I'd like to answer, do you believe that it has to be verbally stated on the record each and every time? If there's 13 different objections, they have to go through that out loud verbally every time, or we must overturn this case?
I think they do have to go through it on each time because each excerpt is a different issue.
Okay, so let's say they have to go through it every time. What
Okay.
obligation does trial counsel, when they don't go through it, have to bring that to the trial court's attention so they can correct that error in the moment instead of put it in their back pocket, wait for an appeal and say they didn't on the record state their findings as to each factor?
Well, I'm not sure, would they really be required to bring, I don't know.
Well,
if
right
anything that
now
says
you're
they're required to
complaining
bring that to
That
them.
the trial judge did not make findings on the record, correct? As to a Binger objection, and she had made those findings as to previous Binger objections on the record. So you have this moment and this exchange, right, with the trial judge right there. You can look at the trial judge and say, Your Honor, with all due respect, you have to make findings on the record as to the factors in Binger if you're going to overrule our objection. Or, I'm sorry, sustain their objection. That did not happen in this case, correct?
Yeah, I'm not aware of that, but I'm not aware of any case that says that you're required to. There's case law after Binger, and I think I cited in the brief too, that the judge does have to, I want to state this right, but the judge has to make, let's see, have held, and this is the Calera case, that's a 2021 third DCA. The Florida trial courts must evaluate the Binger factors and assess the prejudicial effect of excluding so-called late disclosed evidence before excluding the testimony, and failure to do so is reversible error. So I don't see that logic, that really would work here. If you're going to say, well, you can do it one time, and we're going to assume, trial judge, that on these other opinions that came out, right, that you're excluding, you don't have to make the findings on
But
that.
why would
I think you would. I think it too.
Why would I assume the opposite, though? That my capable trial judge doesn't understand the Binger analysis when she just did it? She just did it 5 minutes earlier.
Then she knows it, yes. So if she feels a need to do it for this one piece of evidence, one piece of excluded testimony, why wouldn't she be required to do it for other pieces of excluded testimony? Because they're all different. What if you have, you try to analyze the issue of prejudice, let's say, okay? You can have, maybe there's no prejudice with respect to this one written testimony. But there could easily be prejudice with respect to this other piece of testimony. And in here, it's very significant because Nurse Key was able to testify. So the defense was able to prepare for all these issues, but especially the excluded testimony that we're talking about. Particular deviations from the standard of nursing care in this case. And that Nurse Keith was able to specifically do that. That satisfies the criteria in the case law that, okay, the defense was able to prepare on this issue. They had their experts testify on these issues. So you can say, there's no prejudice here. There's no prejudice. Now, maybe on another piece of testimony, another excerpt, there may not be prejudice, right? Because maybe, you don't have that same situation. So I think every excerpt, right, is going to be a separate analysis. And I think the trial judge has to engage in that analysis with respect to each opinion that's being extended. And that I think is significant. I think it's tough when you go along that line to start speculating.
No, I appreciate it, counsel. And I interrupted you. You started with
Oh,
your
okay,
first point,
okay.
which is
Well,
that they,
Anyway, yeah, so I just think that's really critical because as you know, in the cases I cited, which by the way, Appley did not even respond to in their brief and very significant cases, where the law is clear that you don't even have to, I'm trying to think on the reports and going to that issue of, do we even have a Binger analysis here? You're not going to hold the experts verbatim to their reports. That would be absurd, I think is what the case law said that I cited in the brief. And on that first issue, I don't even think the Binger analysis applies here because there's no new opinion here, all right? The discovery depot was taken. Nurse Attard's report was attached to that depot. And if you read that depot, the only questions that defense trial counsel asked was in the beginning with respect to what documents did you review? Oh, that's a page such and such of your report. But they never got into the concerns, the numerous concerns that she expressed in that report. And if you read that depot, there's a lot of leading, a lot of arguing with the witness and a lot of cutting off the witness, okay? And that was well in excess of a year, right, before the trial depot, way before the trial. They had ample opportunity, if they had any concerns, if they needed to read the report, whatever, to investigate this. And also, even the trial was several days. So they had a chance to if they needed to elaborate, further, to investigate it further, they could have, but they really didn't need to because they had all this information. They had all the medical
So counsel, if I'm understanding your position right, you're saying that if trial court order says that you have to disclose your expert witness opinions, that it's sufficient disclosure if your expert knows it and has the opinion and somebody didn't ask them the opinion. That's disclosure?
Yeah,
And what case do you base that on, counsel?
Tell you what disclosure is, especially. in the
Counsel, but what
report.
case do you base that on? I'm not familiar with any. I think I understand Binger, maybe at least average. I've never heard anybody argue that position, but I'm curious if you've got any case law to support that position.
I do, and it's in the brief because I'm trying to think of the name of it. I'm going to have to, if I can bring it back on rebuttal, because I have time to look at it. But I know I've seen the case on that. Because it says either in the discovery deposition or in the report. And that's why I think the report is very important.
I mean, I don't think the report expressly has this opinion. I mean, if it did, I think you would have put it in your initial brief.
Well,
but,
actually, I think I did put it in my brief. And if you read, and I'm just going to refer you to pages because I reserve rebuttal time. But I would refer the court to pages 16, 17, 18, 19, and 21. Actually, and that continues on 22, where what the nurse Attard is talking about a lot of things. And I know that the opposing counsel wants to say, oh, it's just about lab tests, and that's all she was saying. But no, if you look at the report, she goes extensively into other matters, and she mentions pain. And she talks about, I want to get the exact quote, but taking everything into account. She spoke in those broad terms.
Sign this so you'll.
Oh, okay.
You can continue this As you would like.
Okay, I just wanted to finish, but she spoke in extensive terms on taking into account everything. And I think what the defense wants to do is limit it and say, no, she's just talking about this. And that's what they were trying to do in the discovery depot and kept cutting her off. And I did not cite you the pages of that. But no, they needed to have been asking about the report and the opinions that she was stating in the report. And that's why I go to those cases up there in my brief, and I'll pull those sites that say you cannot say, oh, if you did not mention every exact word, then in your report, then you can't testify to that. And the cases say, no, that's an absurd result. You can't require that. I just want to leave my remaining time for rebuttal. Thank you.
Counsel, you recognize.
May it please the court. Good morning. My name is Taylor McLeod and I'm with the law firm of Wicker Smith. My co-counsel Michael DeLugo is seated behind me and we represent Orlando Health. We are here on two issues. The first is whether the lower court committed error and abused its discretion in striking the very limited opinions of plaintiff's nursing expert Janet Hard. And the second is under de novo review, did the trial court violate the plaintiff's due process rights? Now, at the outset, I think it is critical to emphasize the fact that Nurse Attard was not stricken as an expert. Her trial testimony was merely limited to what was contained in both her discovery deposition and her written report. There are three limited areas that were stricken. Two were based upon the fact that they were not previously disclosed and therefore were Binger issues. And then the other one was stricken because her testimony exceeded her scope as an expert. The question regarding expertise was regarding preeclampsia and whether she was qualified to opine as to what a doctor is supposed to do once a patient is diagnosed with preeclampsia. And then the other issue is with regards to abdominal pain and whether the presence of abdominal pain specifically would cause a nurse in pre-admission testing to call the physician.
Counsel, can you get into that? And maybe you're about to, but your opponent says that that was disclosed. And I think that's preliminary. Do we even get to Binger? Is it disclosed or undisclosed on abdominal pain?
It is undisclosed on abdominal pain. And as you can see, the trial court went through a very extensive analysis of abdominal pain. And in fact, the plaintiff's attorney in the hearing, in the argument specifically stated, no, abdominal pain is not in the report. And abdominal pain is also not in the deposition. So that is very clear. And like I said, I think on, let me pull up a specific citation for you. But the plaintiff's attorney on page 265 of the trial transcript specifically said, I concur with you, that is not in her report.
Right. So that's after the trial judge says, I looked for these specific words are not there. And there was a concession as to that. Could they make an argument generally that it was disclosed without using those specific words?
No, Your Honor. The discussion regarding pain was specific to chest pain. And that the trial court overruled our Binger objections that we were not on notice of a chest pain complaint. And so that I believe Your Honor pointed out at the start of the court's analysis, she went through a very extensive Binger discussion regarding chest pain. And she did say, okay, you could potentially see that there's some chest pain and you were on notice of that. That was not the case for abdominal pain.
Could they climb the ladder of what I call the ladder of generality and say, well, we maybe didn't talk about chest pain, but we did, it was all encompassed in that you should have called the doctor. And
No.
our opinion was you should have called the doctor, and maybe it was for A, B, C, and D, and we articulated A, B, but that we had C as well. And that wasn't a separate opinion. That was just a more comprehensive argument of the opinion we made. What say you?
I would say no, they could not do that, Your Honor. And counsel for the hospital in the discovery deposition asked multiple questions to ensure that they exhausted the nurse's opinions regarding what the reasons for calling would be. And for that, I would cite the court to pages 3503 of the record appeal to 3506 of the record appeal. Counsel for the hospital followed up 3 separate times to make sure that they understood what the specific opinions were regarding the breaches of the standard of care and the reasons why the nurse on August 9th needed to go up the chain of command. So as we mentioned, the pursuant to the Florida Supreme Court and Binger and its progeny, the trial court properly excluded these very limited opinions. As I mentioned, pages 3503 to 3506 of the record appeal go through the multiple instances where the hospital specifically asked the nurse what the specific deviations were. And what I'd like to point to is the language on page 3505, and this is the second time where it was asked. Counsel said, so I need to know the specific deviations. You told me she should have called Dr. Feld to make sure that he was aware of the creatinine result. I understand that. Rather than something amorphous, what is the specific thing you believe she deviated from? And so there it was asked again and asked for specificity. As the trial court properly pointed out, the plaintiffs cannot bootstrap these general allegations with findings in the medical records when the plaintiffs did not disclose these deviations. And there is case law that the plaintiffs cannot idly sit by and know that these opinions exist and that their experts not offering them in the depositions. And that, assuming she actually had those opinions at that time, that's what would have occurred, what occurred here.
Okay, so we're past point one. If we get past point one, right, and we say that it's not disclosed, then we move on to what our analysis is, the trial judge did. Your opponent says that you were clearly not prejudiced. What
Yeah.
say you?
I would disagree with that. As the case, as Binger states, surprise in fact is prejudice. So we were surprised by those opinions. We asked the reasons why, what the specific deviations were, and therefore we were surprised, and that is prejudicial. And the trial court went through the Binger analysis at the outset and is clearly aware of what those factors.
Well, she didn't go through the Binger analysis as to this specific Binger objection. She did it to the one before. Does she have to make findings on the record under Binger?
No, Your Honor. She clearly at the outset of this discussion, which this was very extensive arguments regarding all of these objections. And so at the outset, the very first Binger objection that we made regarding chest pain that she in fact overruled, she went through a very extensive discussion. And to that, I would refer the court to trial transcript pages 258 to 259. And so that shows that she was aware of the analysis that needed to be done in doing the Binger one. There is no requirement that all subsequent rulings that she would have to repeat herself, that the court would have to repeat itself over and over again. There's no case law that requires that.
So you think the standard is, as long as we believe that she knew what the analysis was, she could make shotgun decisions without having to specifically state reasons on each of these?
Well, she did state reasons on all of these. She did not go through the extent that.
She doesn't have to go point by point on each of them.
Correct, Your Honor, because, this is an abuse of discretion standard, and the Binger case law does not say that for every single objection, they need to have a written or a verbal discussion delineating all of them. She went through a discussion of an extensive discussion regarding each of these objections, and clearly at the outset, she stated that she knew what the Binger objections were and she was applying them. This was not just a mere discussion where she said that an objection is overruled or sustained. She did go through analysis on these other issues.
Counsel, what's your position on the issue of whether trial counsel has a responsibility to point this out to a trial court in real time so that if the Binger factors are not fully analyzed or prejudice isn't properly analyzed on the record, what responsibility does trial counsel have in that situation? If a trial counsel sits back and says nothing and lets the court's ruling go forward without pointing out to the court that they have not followed Binger, is that a waiver?
I would believe it is a waiver, Your Honor, because we would not be at that time able to fix it, or we can't fix it now looking back. There was no issues or questions by the other counsel saying, well, I don't see where you found prejudice here. There was no pushback to say, I don't agree with your ruling, or can you explain your ruling further? So I believe that we have to rely on the outset of the argument where the judge clearly understands the analysis and is doing it each step of the way. The last section was in regards to the respiratory therapy argument. And in the deposition, we asked the expert about the respiratory therapy, and she actually said she didn't understand the notation of respiratory therapy in the record. So she clearly did not hold any opinions that the failure to communicate respiratory therapy was a deviation in the standard of care. I would also like to refer the court to the Baptist v. Rawson case, where in that case, that was a medical malpractice case where the plaintiff there was a defense verdict and the plaintiff moved for a new trial based on new expert opinions, and the trial court granted the motion. The first DCA affirmed the trial court's ruling on the motion for new trial, and specifically found that the surprise testimony that was let in was prejudicial by the defense expert. And there, the court specifically states litigation should no longer proceed as a game of blind man bluff. And similar to this case, in the Rowan case, you had a situation where the attorney specifically asked the expert in deposition multiple different times, are these all of your opinions? Are these your opinions? You know, can you specify what your specific opinions are? And that's what was done in this case. Counsel for the hospital asked all of the proper questions during their discovery deposition. And so if these opinions were intended to ultimately be elicited, then the plaintiffs had the burden of disclosing those if their expert did not get those out. I would refer the court to the Conakaris v. Conakaris, Florida Supreme Court for 1980 regarding the abuse of discretion standard. And specifically with that, it is clear that the trial court was utilizing the analysis and had an understanding of Binger when ultimately making these rulings, and therefore a reasonable person could agree with her rulings. Now, the third portion of the testimony that was excluded was in regards to the testimony of the diagnosis of preeclampsia. Nurses do not have the qualifications to admit a patient to a hospital or to order when a patient is to be delivered. They cannot perform C-sections. And so accordingly, the trial court allowed the nursing expert to talk about preeclampsia and what it meant. But the limitation was extremely small. It was just one question, and that was where Nurse Attard was testifying that the diagnosis of preeclampsia meant that the patient needed to be admitted to the hospital and that they needed to deliver. And that is not within the nursing purview. And so for that, I would refer to pages 245 to 246 of the trial transcript. The second issue that plaintiffs are claiming here is that the exclusion of limited testimony violated the plaintiff's due process rights. Even applying a de novo review, that argument should be rejected. The cases referenced by the plaintiffs all deal with situations where the expert was stricken as a witness. Here, she was not stricken as a witness. She offered extensive testimony regarding the purported deviations. And specifically, I'd like to refer the court to the following citations from the record of appeal where Nurse Attard was testifying that the nurses deviated in the standard of care on multiple days. That would be record on appeal pages 5715, 5717, 5718, 5719, 5722, 5723, 5727, 5728, 5733, 5744. These citations all demonstrate that the plaintiffs had the ability, that the plaintiff's ability to have their nursing expert overwhelmingly testify as to the deviations of the standard of care by the nurses, including Nurse Vasquez on August 9th. Based on the above, we believe that the final judgment should be affirmed in all respects, and unless the court has further questions, we will rely upon the contents of our brief. Thank you.
Okay, thank you, Councilor. You recommend?
Okay, we got that set for me. Okay. I do just want to follow up with, I think Judge Smith's question. I'm just going to refer you to 3681 to 3683. I believe in the new trial, the trial counsel did give the trial judge an opportunity to correct the error prior to the appeal. If the 3683 says the Binger standard was not met as to this testimony. So I did want to follow up with that. And let me just say, and there's a lot to cover here. I want to make clear in the discovery deposition of Nurse Attard, she said at, page 3505, she made clear nurses breach the standard of care by not calling the doctor when one takes into account everything in total. And she talked throughout the deposition of preeclampsia, which, you know, abdominal pain is a symptom of preeclampsia, and then the respiratory therapy, and considering her medical chart, and that's what everybody's going by is the medical chart. And certainly Nurse Keith was able to give all kinds of opinion testimony with respect to the medical chart. Nurse Attard was not. And what I find interesting is in the deposition, what they left in And that was the problem. I mean, they left in some, Nurse Target testified to some, data points basically, but she couldn't make the connection, right? She wasn't allowed to say, well, that was a deviation of the standard of care, not to go up the chain of command, with respect to what was showing on the medical chart and how the patient presented. But at page 43, that's R5727 question, and this was allowed in, as a registered nurse, when you see the patient, pregnant patient complaining of pain, is that important to you? Yes. And yet, when she's asked the question, this is what was stricken. Upon learning this information of the complaints of pain in the abdomen, tightness, intermittent by way of description from Ms. Lavity, does the applicable standard of care require Nurse Vasquez to call Dr. Feld or some other medical doctor? Objection. And then that was rephrased. And then she said, yes, the presence of pain would cause any nurse in pre-admission testing to do some fetal monitoring, to call Dr. Feld to see if he's willing to perform an MST. And that is one of the key items that was excluded. And what you've got when it goes to the jury is, okay, remember, the only expert that plaintiffs had basically left is was the nurse regarding nursing standard of care, was Nurse Attard, okay? And she was excluded. So the jury, while plaintiffs can say, this fact, they could not present any expert testimony because the key expert testimony connecting the dots, right, with the deviation of the standard of care, the nursing standard of care was excluded in this case, okay? And I think certainly under the Binger analysis, to say that to say that this was surprise, in fact, no way. Read Nurse Keith's testimony. She got to cover all those points. And oh my goodness, on preeclampsia, just read the depo because I don't have time to read everything, but the court has it before them. And I think I quoted it, sure, in the brief. They want to say, oh, well, it's a diagnosis. She's a nurse. She can't talk about diagnosis. That's not what was going on. She was asked in her experience, what's usually done when there's been a diagnosis of preeclampsia. And there was a diagnosis, clearly. There's no dispute about that. And yet she was not allowed to testify to that. But Nurse Keith was allowed to testify to that. Talk about asymmetry and a one-sided case of experts. And that's exactly what happened in this case. Okay. So, and why emphasize Nurse Keith is there was no prejudice. And in the third DCA case that I cited, they make it clear that's going to be reversible error.
Counsel, are you talking about the Kalari versus Winklejohn case?
Yes.
So in the Kalari case, there was a motion for reconsideration filed after the striking of the expert.
Mhm.
Did you file a motion for reconsideration?
Oh, I don't recall. I'd have to double check the record, but in the motion for new trial, though, I know that the trial attorney had raised.
But from a timely perspective, obviously that's after the trial. I guess my point is that as I read Kalari versus Winklejohn, I don't see anything in there where the court says that there's no responsibility on trial counsel to raise this to the judge in real time to let the judge know that they didn't follow Binger. In fact, if anything, if I'm reading between the lines, it does seem like they probably did raise it. It's just not clear. I'm wondering, do you have any case that's a little clearer than Kalari that says that you don't have a responsibility to raise this to the lower court? That it's essentially fundamental error analysis.
It's not like a negative. I don't think that I don't know of a case that requires you to raise that, especially in a motion for reconsideration, right? They're going through, doing all this argument. I don't see where there's a requirement to raise that after the court's ruling, Your Honor. So I can't cite you a case that says yay or nay on that. Okay. And when you go to the depot, because I think the cases I cited, let's see, that's the Suarez Burgos case, 745 Southern 2nd, 368, and the Allstate case, 14 Southern 3rd, 1290. Limiting an expert's testimony to the exact wording of his or her written report, however, would create an absurd result. Such reports often contain complex medical terminology, which requires extensive explanation. When you look at the depot, I'm sorry.
Your time's up.
Okay, can I have 30 seconds to wrap up? Thank you, Your Honor. I would just refer the court, look at pages, these are examples, 95, and if you look at the deposition, Nurse Attard does touch on a variety of the factors, but she's never really allowed to finish. And they want to harp on, well, he asked the magic question, okay, do you have any other opinions? Well, as far as Nurse Attard's concerned, she submitted her report. So it's up to defense counsel to pull that report out, say, well, what do you mean by this? What do you mean by that? And that was never done in this case. So for the reasons I rely on my brief, Your Honor, I think the brief covers this in extensive detail. So we would ask that this be reversed and remanded for a new trial. Thank you.
Thank you.